Iku Iluna. Please rise. Ohea oko e koka aha, inahe kuliana imua okea aha ho'o kolo kolo ki ike hanahano o ka moku aina o Hawaii. E nai mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu. Please be seated.
Please call the case.
Consolidated case numbers SCAP-24-0000111 and SCAP-24-0000396. James Dannenberg and Sarah Preble, individually and on behalf of all others similarly situated, plaintiffs appellants cross appellees versus State of Hawaii, Hawaii Employer Union Health Benefits Trust Fund, and Board of Trustees of the Hawaii Employer Union Health Benefits Trust Fund, defendants appellees cross appellants, and County of Kauai, County of Maui, County of Hawaii, defendants appellees cross appellees, and City and County of Honolulu, defendant appellee cross appellant. Arguing for James Dannenberg and Sarah Preble, Paul Alston. Also appearing is John Rhee. Arguing for the State of Hawaii, Hawaii Employer Union Health Benefits Trust Fund and Board of Trustees of the Hawaii Employer Union Health Benefits Trust Fund, David Louie. Also appearing is John Price, Paul Aoki, Nick Monlux, and Ryan Louie. Argument on the merits.
All right, good morning, everyone. Aloha kakahiaka. Today's proceeding is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. First thing I'd like to do is acknowledge and thank the substitute justices on this case. Chief Judge of the Second Circuit, Peter Cahill. First Circuit Judge James Ashford. First Circuit Judge Lisa Cataldo. First Circuit Judge Jordan Kimura. Counsel, are you ready to proceed?
We are, Your Honor.
Okay. So the court has allowed 30 minutes for each side. And Mr. Alston, you have requested an initial 20 minutes, 10 minutes rebuttal. Mr. Louie, you will have 30 minutes. And I understand you folks have discussed with the bailiff the warning lights that you have that you would like, the timing. Okay. Mr. Alston, please proceed.
And may it please the court. On behalf of approximately 100,000 present and future retirees and the estates of another 20,000 who died during the quarter century covered by this case, we are here for the third time asking that you protect the rights of the retirees under Article 16, Section 2. We ask that you vacate and remand on all the issues presented by our appeal. The house of cards that constitutes the decision by Judge Crabtree falls because he did not follow the framework created by the Alaska cases, that's Hammond, Duncan, and the most recent case, retired public employees, and by this court in Dannenberg. In addition to barring changes to retirement benefits that cause undue hardship or major reconfiguration or go outside the mainstream, those cases require that diminished benefits be accompanied by new enhancements that, one, as I said, accompany the diminishments, two, relate to the benefit diminished, and three, have a comparable economic value. Those requirements create a comprehensive and cohesive three-part test that affect the timing, the type, and the value that has to offset any diminishments. Judge Crabtree committed fatal errors in all three. First and most obviously, he rejected outright the requirement that the offsetting enhancements relate to the diminishments because he couldn't find the word related in the Duncan opinion. In fact, the word relate and the phrase relate generally to the diminished benefits appears not only in Duncan and RPEA, the subsequent Alaska Supreme case. It also appears in the Dannenberg case, and it sets a requirement that there be some nexus between the two.
In Dannenberg, the relatedness language is with regards to the discussions of those other cases.
That's
right?
correct, Your Honor.
And I think it's an interesting point for sure. And the question is in terms of Judge Crabtree being very precise to the holdings in Dannenberg. Can you address that?
Yes, I can, because what you see in Dannenberg is an adoption broadly of the framework created by the Alaska court. To be sure, Dannenberg didn't go word by word, line by line, and say we adopt this, we adopt that, and so forth. But it did, in I think clear terms, reflect that it found instructive the teachings of the Alaska Supreme Court, and there is no hint in Dannenberg that it was adopting part but not all of the analysis. And I think Judge Crabtree said, well, I'm going to disregard entirely relatedness, and I'm going to look instead just for comparability. But those aren't synonymous. They aren't alternatives under the Alaska cases, and indeed under the underlying California Supreme Court cases going back to Betts in 1978. They are different parts of a multi-part test. And there is nothing in Dannenberg that suggests that it was going to take part of those cases and not the full framework, because otherwise you're left with an incomplete basis for analysis. So
if I could ask you, Mr. Alston, in this case on the remand after Dannenberg and at the trial, the focus of the, I guess the diminishment for the plaintiffs was increase in cost sharing,
correct,
right? So can you tie up for us how the relatedness versus the comparability impacts with regards to, there wasn't an argument that coverages were lessened. It was, as I understand it, it was the fact that cost sharing increased.
That's correct.
So how does it matter one way or another?
Well, it matters enormously, Your Honor, if I could, because what happens is that when the cost sharing increases, it's the equivalent of moving from something we all know now, the difference between a 90-10 plan and an 80-20 plan. What happens is instead of getting rich benefits, you get less valuable benefits. And Joint Exhibit 121 reflects that in making the switch to the PPO, what the state did was notify retirees that, by the way, instead of the $1,500 annual copayment that you and active workers enjoy, when you retire, you're going to have to pay $4,500 as a family, and so forth. So what happens is that the quality of the benefits go down just because of cost sharing. And I think that what Duncan and the other cases require is that you can't just cut back on the value of the benefits. There has to be a new enhancement of equal value, and it has to relate to the benefit that's being taken away. So that, for example, if you're going to make people pay more for their drugs, you better give them access to new therapies. You better give them access to things that might previously not have been covered in the way of medical treatments, or therapies.
So when you're saying relatedness, it's more like related to those cost increases for drugs, and comparable is in your mind a comparable value.
Yes, and the word comparable, the concept of comparability comes out of the pension cases, and it's tied there because what the court says in Hammond, which was a benefits case, a money benefits case, is that the change has to be of equal dollar value. And that's what I think the concept of comparability meant there, and what it means in the healthcare cases. And so, again, there has to be, you have to, in order to make a change, you have to cover all three bases, and the change If it affects the cost of drugs, the cases teach you've got to have a related improvement that affects that benefit. You can't take away drugs, or in the case of the retirees, in our case, free hospitalization, free surgery, and free nursing care, and give them podiatry benefits or well baby benefits, which are the kind of things you see in Appendix G, or which their expert came forward with. Appendix G is instructive because even if you, well, first, if you confine the search to exactly what the cases teach, that is related, accompanying, and of equal value, if you look at Appendix G, you don't find anything that could be offsetting. And of course you won't find it because they weren't looking for it. They thought they could cut back benefits freely. And so it should have been easy for us to satisfy the test if it was properly confined. I think it was properly confined to things that met the three-part test. But when you open it up to the entire universe of things, and you open it up almost without regard to time limit, so you're not looking for things that accompany, you're not looking for things that are related, you're just looking for anything in the universe. You know, maybe Judge Crabtree was right. There's something in the universe somewhere, but the defendants didn't point it out, and they certainly didn't point out anything that was contemporaneous and related to the added costs they dumped on the retirees.
Well, that goes to the burden of proof, right? I mean, that was another big part of the decision, and I know you're challenging that.
Right, and in fact, Judge Crabtree was wrong. He said that the state could simply play defense and do nothing, right? But Duncan and the other cases show that that's wrong. In Duncan, the Supreme Court of Alaska expressly put on the state the burden to show that it wasn't making changes that imposed undue hardship, and that it couldn't provide the retirees with the opportunity to keep their old program instead of losing something important. So it wasn't simply a one-way street. And when you look at Duncan when you look at the cases on remand, we cited this. There's a case called Matiashevsky out of the Alaska Superior Court. That court said the plaintiffs have the burden of persuading the court that there was an imbalance, but that the state has the burden of showing compliance with the framework, which makes sense because they're fiduciaries, and their analysis should always have been, we're taking something away and we're giving something back. But here, there was no give back because they thought they could get away without giving anything back. And for more than a decade, that's exactly what they did. So with respect to the burden of proof, I think Judge Crabtree got it wrong because the framework in the Alaska cases shows that it's not simply a one-sided burden, and it's an impossible burden if you don't narrowly confine the search to things that are related, accompanying, and of equal value.
Well, one of the things that's challenging, it seems in this case, though, is as you started with, I mean, hundreds of thousands, you're seeing 100,000 retirees as of this moment, but even when the case was filed, I think the number I saw was like 30,000. And in terms of, I mean, it just seems to cover such a wide range of individuals that have a variety of circumstances in their employment for the state or county. So I think that's, you know, in terms of just showing what the disadvantages and then what potential offsets are, isn't that part of the challenge in this case? I mean, I don't
think it is, and for this reason. If you look, as Judge Crabtree correctly found, if you look through the entire history of the Public Employees Health Fund for nearly 40 years, everybody was on the same page. Everybody got the same package of benefits. Right. And so it is against that common package that virtually everybody indeed everybody in the class gets the first look.
Well, it wasn't the same throughout those 40 years, though.
No, it wasn't. It did get better, but as Judge Crabtree recognized, as it got better, that became part of the accrued benefits.
And that's because the statute before 2003 required equivalent
It's
between the active employees and the retired employees?
It's actually for two reasons. It's one, the statute talked about uniformity, and secondly, there was a promise of continuity. There was a consistent promise when people were hired that what you got when you were hired, or what you enjoyed when you were working, would continue after you retired. And it's that promise of continuation that sets the floor for what is to be provided after you retire. And that's, if you go back to Everson, Justice Acoba addressed that issue in his concurrence and said it's the best package anybody gets while they're working because of this promise of continuity. What you get is what you keep. And that's the way it always was. And remember, our class involves only people who were hired before 2003. And so it was everybody in the class got accrued benefits based on the promise of continuity. And the only question really is not whether they got to keep the best they had in 2003, but whether the people who continued to work after 2003 still enjoyed the benefit of continuity. Judge Crabtree said otherwise for all the reasons that Justice Acoba noted in his concurrence in Everson. We think he was wrong on that score, and that the post-2003 benefits are also protected. I think if I could, I would like to turn to the second major issue in this case that stands entirely apart from this whole discussion about medical benefits, and it's the life insurance claim. Judge Crabtree wrongly found that life insurance was too trivial to be considered, but the cases teach that once a benefit is extended to someone and promised to them in retirement, it becomes accrued, and big or small, that has to be honored. The Hammond case, which is the seminal case out of Alaska, was a life insurance case. This is the same. And what happens is that there is a unique statute that covers only life insurance. And that statute says that beginning in 2004, the base minimum contribution that each of the government entities is required to make has to increase with the Medicaid premium increase. And what that means is in 2004, when they were getting about $2,000 each, if you take it to today, it would be about $8,000 each. And Judge Crabtree found that was unimportant, but when many, if not most, state and government and county retirees live on low incomes or even very low incomes, that amount upon death is part of the bargain that has to be honored. And it ought to be at $8,000 or whatever the Medicare formula, the statutory formula requires. You can't just write it off and say it's trivial, it doesn't matter. If it was given, it's got to be honored. And all told, because about 1,000 people die a year, that's the total now is somewhere in the neighborhood of $80 million. That's a significant amount for the retirees of the state and counties that worked their entire careers to get the benefits that they were promised. The third point I'd like to address is dental vision. Judge Crabtree found that the retirees were not entitled to protection based on inflation. But what we were talking about is not just inflation, the concept, although that's a concept that relates to what we were asking about. We all know state retirees' benefits, their pension benefits go up at 2.5% a year. We weren't asking for anything like that. What we were asking was for benefit maintenance. If you look at what retirees got in 1990, if they had a dental problem, they could get 3 crowns put in. Because the state and counties allowed that benefit to stagnate for 25 years, when you got to 2015, they could get 1 crown filled. And what we're saying is when there are material price increases in a benefit, the state has to, at appropriate intervals, adjust the coverage. It can't set a dollar limit on the coverage and let the benefit deteriorate the way it did.
I mean, how do you, ultimately you have to analyze that by going back to what the accrued benefit was while they were employed, though, right? What they were promised, I suppose,
Indeed.
While they were employed, what their retiree benefits would be.
Indeed.
So your argument is that what evidence specifically goes to that?
Okay, there were in the record the schedule of payments from Hawaii Dental Service, both from 1990 and from 2015, and so you could follow it through the years. There was there was in many respects no shortage of documentation for the things that were covered by this.
Mr. Austin, there's one area though, I think, and it kind of touches on a variety of the issues, is in your point of error number 4, you're challenging Judge Crabtree's assessment of what accrued benefits are, specifically because he references it as what the active workers were being offered in their last year of employment, with retirement occurring no later than June 30th, 2003.
Right.
And is that, I guess my question is, it seems like an odd statement also because, as you've noted, a lot of the employees continue working past 2003. Is that last part of that sentence because the statutes change and you didn't have equivalent active and retiree benefits?
That's what Judge Crabtree found. Our view was that the overriding promise, or the overarching promise of continuity, didn't allow the sudden retraction of benefits for people who were in the middle of their career or near the end of their career. That once they were promised continuity, then they're they're working in the 30th year or 35th year of their career. The state doesn't get to say, yes, you're going to have these benefits, this new package under the PPO system, this new package of benefits. But in retirement, unlike before, you're going to have to plan for the economic hit you're going to take when your benefits.
So that's for somebody who retires, say in 2010 after.
Yeah, that's right. Okay. For people who retired after
2003.
2003.
Okay.
Okay. For people who retired in 2003 or earlier, we know what the package was, right? Now the history showed that for its own reasons, the state always provided and added, when benefits were added, everybody got it, no matter when they retired. I have to say that when somebody retired in 2003, they have no claim to it. They have no claim to post-retirement improvements, but the state and the counties can provide it because they think it's a more efficient way to deliver services. On the issue of fiduciary duty, Judge Crabtree found because there was no harm, there was no foul. When you properly restrict the search for offsetting enhancements, as we've described, and find that there is nothing there, or find that a trial judge properly guided would find nothing, then that decision falls, the finding of no fiduciary duty breach. And it falls not only because the trustees as fiduciaries had an obligation to follow the law, which requires balancing, which they never made, but also because when they found out from this court's decision in Dannenberg that they were wrong, they never went back and said, gee, for 15 years we've been doing this wrong. What harm did we inflict on people? They should have looked. And to say they didn't have a duty is nonsensical. Lastly,
thank you, Mr.
I know I'm going to eat into my time, and I know a minute. Very quickly on attorney's fees. Judge Holm has said we weren't the prevailing party. If you look at the whole history of this case, from Everson through Dannenberg, through the fact that in 2014, the defendants stopped reducing benefits by increasing copays, and that protection has continued all the way to today, you would have to say in any fair analysis under food pantry that we're the prevailing party under the Assumption statute.
Thank you, Mr. Austin.
Thank you.
Mr. Louis.
May it please the court. There's nothing novel here. There are no new issues here. The question here is whether or not the trial court, Judge Crabtree, was correct that the plaintiffs simply failed to prove their claims under the Dannenberg analysis, and the answer is yes. There's 4 main points I just want to emphasize. First, Dannenberg, not Alaska. We're not talking about Alaska. This court is not a junior court of Alaska. The Dannenberg opinion was a comprehensive, holistic evaluation process, well-reasoned, well thought out, that gave a roadmap for the plaintiffs to follow and said, this is what you're supposed to do. This is Hawaii law. And it noted that accrued benefits are a reasonable package, not specific benefits, not one benefit here or one benefit there, a reasonable package. It provided a flexible analysis, 4 guideposts. We'll talk about that later, but most importantly, the court noted that it is a group analysis because health insurance is on a group risk basis. It's very different from pensions. Second point, instead of applying the Dannenberg analysis, the plaintiffs focused only on cost sharing, which is a small part of the reasonable package. And they ignored some very basic facts, which are, 1, medical and drug benefits have always gotten better, always. No dropped coverages, no deleted coverages, never happened. And there has always been cost sharing from 1961, always cost sharing and always increases, always going up over time with the benefits. There was no promise ever about increases. Judge Crabtree found that. They didn't dispute that. And they left out the biggest part, which is that Medicare coordination of benefits, Medicare pays first. It pays 80%, and then the plan comes in and pays mostly the other 20%, mostly, so that most people over 65 retirees pay little or nothing. So they're talking about this little tiny thing so that they could get some money. Third point, they didn't follow the Dannenberg analysis. There were 4 guideposts. Has the plan changed the core benefits? Answer, no. Has the retirees plan been in keeping with the mainstream of actives? Answer, yes. Is there equivalent value? They didn't provide any equivalent value. Their guy, Mr. Brandon, admitted he couldn't provide a damages analysis. They never provided any equivalent value for what they claimed was disadvantage or what they claimed, and the judge found, they didn't look at the offsets, and they never made an offset analysis. They simply provided this PRV analysis, which is a flawed metric because it measures a ratio. It never provides equivalent value. And the 4th point is that because of their failures, they want you to rewrite the Dannenberg case. They want to ignore the trial court's exhaustive review, the EUTF's exhaustive review, the Dannenberg court's exhaustive review, and simply rewrite the whole opinion because they don't like the definitions. So we ask you to affirm.
So let me ask you, Mr. Louie, in addressing Mr. Alston's argument about why Judge Crabtree should have defined either relatedness or comparable benefits. In your view, how does that fit in with the actual evidence that was adduced at trial that only went to cost sharing?
Sure. First off, you don't need to define comparable. They cite that as a big point. Comparable means the ability to compare. It's got a plain meaning. You don't have to define that. What does related mean? Related is not part of the Dannenberg opinion, except, as you have noted, Judge, part of their discussion of Alaska cases. But the actual holding says nothing about related benefits at all. And so, as it relates to cost sharing, quite frankly, Justice, the whole point is that they cost sharing relates to many things because it goes to doctor's visits, cost sharing for that. It goes to drug benefits, cost sharing for that. But it goes to who uses it, who uses the services. Not everybody pays. It's when you use the service, you pay a cost sharing as a fair share, kind of skin in the game kind of a thing. There's all these reasons for that, but it varies, and it varies substantially. So that everything, actually a lot of things are related. They want to cherry pick certain benefits, some benefits, and say, well, you can't do this cost sharing for that without doing something on that. But cost sharing is not like that. It's across the board.
If I understand the experts' reports, testimony essentially is the state, even though Judge Crabtree said you didn't have to provide this evidence because you could play defense, but your expert witnesses talked about expanding coverage, other things that benefited the retirees other than not just cost sharing issues, but other benefits that increased over time. So in your view, does that need to be comparable, related? Obviously not related, but does that need to be comparable to the cost sharing
We
increases?
believe that we actually provided a comparability analysis. I had two experts from two different things, one an actuary and one an economist. And they actually provided two analyses of the total value, what was given to the plaintiffs on the total package, what it costs in the open market as the value. And they factored in cost sharing into that and showed, both of them, that over time, the values always went up. The values, maybe 1 year, there was a little bit of a dip because of certain factors. But that's because cost sharing varies depending on year by year. Different people go to the doctors. Sometimes there's more surgery. Sometimes there's more pregnancies. Sometimes there's more drugs. So they want to say, well, there's a static number. There isn't. Cost sharing varies, and the ACA, the Affordable Care Act, recognized a 4 to 6% variability up or down for cost sharing in order to achieve equivalence, because there's an inherent variability in cost sharing that changes year to year. So you can't just say, oh, well, the ratio is different this year, so therefore there's a disadvantage. That's not true.
Is this your position, Mr. Lee, that you have to look at it as a group benefit and not per person or per individual? Because per individual is exactly what you just said. But it was comparable based upon the group benefit.
Absolutely, Judge Cahill, absolutely. We believe that, and they didn't look at that, and they just didn't do any of the Dannenberg analyses. And it's one thing to say, well, the court got it wrong, but they didn't present anything. So that, why does the court need to define something when they have presented no evidence?
The appellants have made a great deal here this morning about the promise of continuity. How was this promise made? Was it made to individuals? Is it set forth somewhere? Or is this just an understanding that when you went to work for the state or the counties, oh, by the way, when you retire, you're going to have exactly the same thing?
Right. So on the promise of continuity, we believe that is a flawed theory. What the Dannenberg court said was the starting point is retirees' benefits. Okay, and there's always been separate plans. Actives, even though they were identical, actives have had a plan, retirees have had a plan going forward. So that the issue, and Justice Ganoza raised Judge Crabtree's formulation of this, we think that was slightly in error, was that Dannenberg said, look at what the retirees were getting, because the promise is when you retire and you move from an active to a retiree plan, you get what the retirees get. And that's your promise. That's the accrued benefit. And now it happened to be identical, so that in the last year of before 2003, it was the same. But in fact, Dannenberg says, look at the retirees package. That's your starting place. And so continuity, their theory of continuity, that they get something as an active, that was added after 2003, and that somehow they get to keep that. It was never offered in the retiree plan, ever. They've cited chiropractic or some increased dental. It was never offered in the retiree package. So the whole question there, which we believe is a flawed analysis, is not adding something, is not taking away. And the non-impairment clause in the Constitution says you're not going to diminish, you're not going to impair. Well, just because you didn't add something, that doesn't mean you diminished or impaired. Does that answer your question,
Yes,
Judge Cahill?
So let's talk about that point of error 4, which is where Judge Crabtree defined the accrued benefits according to what the active workers were receiving last year of employment, with retirement occurring no later than June 30th, 2003. I think I heard you say you think that's a little bit an error. How would you revise that?
Well, I would have revised that, and we had urged Judge Crabtree to say, you got to look at the retiree benefit that was offered in the last year of 2003, or is the last, whatever the retiree benefit is when somebody retires.
So somebody starts working for the state in 1990, retires in 2010. It doesn't matter. It's just what were they offered as their retirement benefit in their last year of employment?
Yes.
Okay.
Right, because the Dannenberg says it's the starting place is what the retirees got, and because they're separate plans, the promise is when you retire, you will get what the retirees are getting, as it improves, and whenever you retire, whatever that is, that's what you're going to get, and that makes sense.
It's really essentially just lopping off that last part in terms of requiring retirement by 2003 in terms of that particular language, right? Okay.
And the other point on the continuity thing, Justice Canosa, is if you buy their thing, then every time there's an added benefit for an active, and then they retire, we have to change the whole plan for the retirees, or we have to offer 1,000 different plans for 1,000 different individuals who retired at different times. That's crazy.
I thought Everson and Dannenberg already addressed those two things, right? Everson under the statute, Dannenberg under Article 16, Section 2. The equivalent argument is no longer, I mean, that's been addressed by those prior cases.
Exactly.
Equivalent between active and retirees going forward.
Yes, and so we think that the continuity theory is really just a parity theory, parity light theory. It's parity by another name that would not work, and it ignores, the careful analysis and the structure of the EUTF, which really is designed because you've got these trustees and you have equal trustees on management and unions. They all have to agree to either add something or to take it away, and certainly none of the union trustees are ever going to vote to take anything away. So there is an inherent thing there that we think this court has already addressed in terms of Chevron deference, where this court has stated its disagreement with the U.S. Supreme Court of getting rid of the Chevron deference thing, whereas here in Hawaii, we believe in the excellence and the analysis and the exhaustive review of these agencies, such as the EUTF, to make these kinds of decisions. So let me turn to a couple of points that Mr. Alston raised. He talked about fiduciary duty. I thought it was a bold move for him to say that C.J. Rechtenwald was negligent, and to say that the trustees were negligent in this. But the whole point is that they have never proved some breach of fiduciary duty. The EUTF has been incredibly careful with what it did. It has always used consultants. It has had RFPs and contracts that are in place and have always been in place, even before 2003, where they told HMSA and Kaiser, you know what? When you bring your new plan forward, and we're going to pay the premiums for your plan, we're not taking care of benefits, we're going to pay the premiums for the plan. When you bring that plan forward, you make sure that it is as good or better across the board of everything that's been come before, all the plans. And every year, HMSA and Kaiser would say, yep, that's right, we agree with that, and they put that in their contract. And so for them to now say, well, that's just wrong, they didn't do it, is a hindsight analysis for which they provided no evidence. They provided no evidence. The interesting thing was their guy, Mr. Brandon, admitted multiple times that he was not providing a damages analysis. In fact, I asked him so many times, Judge Crabtree told me to give it a rest. And he admitted that. But if you're not going to provide a damages analysis, that's liability and damages. Those are two basic critical things.
Well, the plaintiff's argument is that Mr. Brandon's opinions, the planned relative value theory that he presented, encompasses the offsets as well. So can you address that?
Sure. He uses what he calls a PRV analysis. And it is the flaw, it's a flawed metric because PRV stands for plan relative value. It's not plan equivalent value, which is what Dannenberg requires. It is not plan actual value, which is what Dannenberg requires. It is plan relative value. And so what it is it's a ratio of what the cost sharing is in any given area, in any given year, as to what percentage of costs were paid by the plan and what percentage of costs were paid by the members as a group. And the problem is as I mentioned earlier, cost sharing varies year to year. The ratio varies year to year if everything remains the same, just because you're going to have different pregnancies, different drugs, different surgeries. And so using that ratio is a flawed metric. And the example given by Mr. Snook was, if we've got an Applebee's dinner and a Morton's dinner, and one child gets Applebee's and pays, let's say it's a $100 dinner, and they, or I'm sorry, a $50 dinner, they pay 10%. That's a 20. They pay $10. That's a 20% tip, and then the daughter gets $200 Morton's dinner and pays $40 as a 20%. She's gotten gigantic value, but their analysis says it's the same value because it's the same ratio. And, if the daughter was to pay extra, to pay, say, a 25% tip, they would say she got a raw deal. She lost, even though she got actual value. So that's why the Brandon PRV, plan relative value analysis, is a flawed metric to try and evaluate this.
I think what I'm hearing you say in terms of like value is like, a Denny's breakfast, Grand Slam breakfast is not the equivalent of a Morton's prime rib, dinner or something like that, or steak dinner. How do you, I guess part of the question that I saw the plaintiffs raising though is, how do you value that quality or quantify that? A Denny's versus a Morton's.
Exactly, and that's what we did with Mr. Snook and with Dr. Baker. They took the actuarial data. We actually went and looked at all of this data in minuscule detail over as many years as we could get data for. And then they did this analysis to figure out what does it cost in the open market to buy these services, and that is how they determined value, because that's what, if nobody had an insurance plan, that's what you would have to pay for these things as a group, and then they factored in the cost sharing, what actually got paid as cost sharing, and their conclusions were that over time, every year, it always got better. And the reason why that matters here is that the plaintiffs have said, well, we don't have to pay cost sharing. See, cost sharing has always gone up as a factor, and that's just been a given. Ms. Preble.
To a certain level, not Judge Crabtree said it has significantly increased though.
Yeah, and exactly. And so because their witnesses testified that it has always been expected to go up, the real question, which they never tried to answer, is, well, did cost increases go up more than normal? Judge Crabtree noted that if you were going to look at modest increases in his Phase 2 FOV call, he said, if you're going to look at that, you need to ask yourself, did the increase go up more than expected, more than normal, so that it was, in truth, some kind of a disadvantage? See, they want the benefits of all improvements medical technology, new drugs, new services, better doctors, better education, and in fact, new benefits that get given by the ETF. They want that benefit, but they don't want to pay the fair share of the cost. The burden goes with that.
Was there any difference in the record that would show, Mr. Louis, that there was a difference in benefits between retirees who were not Medicare eligible and retirees who did receive Medicare? Because once you hit 65, if you're retired, you go into an entirely different system where Medicare becomes primary. And then I guess the offset to that is if you're collecting Social Security, they reimburse, or you don't have to collect Social Security. You get reimbursed that difference that you'd have to pay.
And their guy attempted to do that analysis with certain limited things. But again, and the reason why we say that was flawed was because now you're cherry picking certain specific benefits when you're supposed to analyze the entire package. And our guys analyzed the entire package and said, you know what, it's always gotten better. There's always been this increase in value. So that to look at the non-Medicare retirees who are the under 65, guys who retire early, people who retire early, but when they get to 65 in general, not everybody is, Medicare, but almost all do.
And some of us are Medicare, but we're still working.
Yes. and so once you hit 65, the practical reality is almost nobody pays anything. So that for the entire group, and you have to analyze the thing under Dannenberg as a group analysis because that's how the plan comes at it. It's group health insurance. So that the number of non-Medicare retirees is relatively small. I don't know that number, and nobody's actually figured that one out.
So going to the attorney's fee issue. If you could say that this promise of continuity is not really a contractual promise, then why is 607-14 even an issue? Because essentially it comes down to a breach of fiduciary duty, and that's more of a tort, not a contract.
Right. So our view, Judge Cahill, is that there is no way that they could be considered a prevailing party. And the Unite here 4 months ago, the precedent by the Supreme Court that says you got to be the prevailing party to get the private attorney general thing. Since they lost on every count, it's really hard for me to see that they're a prevailing party. Their argument is, we established important doctrinal things, but quite frankly, we don't agree with that. And ultimately, their causes of action were denied and dismissed by Judge Crabtree, and so they can't possibly be considered to be a prevailing party.
Okay, I get that, but 607-14 for attorney's fees applies to actions in a subset, right?
Yes.
And only in a subset.
Yes.
But if there was no contract and you proved that, then how do you fall for attorney's fees under 607-14? Simply because they made the argument?
So yes, they made the argument, and in fact, our claim for attorney's fees, and quite frankly, I'll rest on the briefs on that, although we'd like them, but I'll rest on the briefs on that, and their claim for attorney's fees under 607 would not exist.
Okay, my last question, well, maybe not my last question, but my last question on the attorney's fees is, somewhere in there you made an argument that it's joint and several liability, right, for attorney's fees.
Yes.
But joint and several liability is a tort concept, not a contractual concept, unless there's a specific provision in a contract that specifically says, we agree to joint and several liability. So how do we get to joint and several liability for all members of the class or the named members if that's a tort issue?
And, I acknowledge that, Judge Cahill. I would say this. Number one, first, the named plaintiffs in my view, should be liable because there was a period of time when they brought these contract claims, there was no certified class. And they're the ones who brought the claim, and then they should be responsible for it. But if you're going to go down the road of there's a class, then as a matter of fairness, then everybody in the class should share. And the plaintiff should, or whoever's getting the attorney's fees should be allowed to get the attorney's fees.
On that issue with regards to the class, what period of time was there notice to the class?
I'm sorry.
At what period of time was there notice to class members? I know that after Dannenberg was issued, there was a recertification of the class.
Correct.
Okay. Did notice go out at that point?
I do not
to class
know
members?
I do not recall that a notice went out, but I honestly don't recall. Let me just note that, Mr. Aoki of the city and county graciously allowed me to take all of the time. And I told him that in exchange for that, I would read a statement. So if I might just read this statement from the city and county. The city and county has said, the trial of this case confirmed that the counties operated strictly within the statutory framework of the Hawaii State Employees Retirement System. As a result, there is no basis for direct liability between the plaintiffs and the counties. If at the end of this case there is any requirement for additional funding, that will be a matter for the EUTF and the counties to resolve. This subject was not an issue addressed in this lawsuit. The EUTF and the state are in agreement with the counties on these points. So that's the statement for that, and so that I've honored my commitment to Mr. Aoki. I think, and if I might just address in the time I have left, the life insurance claim we think is just a total. One, it contradicts what Judge Crabtree found, which is that there was never any promise, and they never submitted any evidence of a promise separately or some kinds of thing that people reasonably believe that they would get something in life insurance. The life insurance commitment here by the state has always been a creature of statute. And our position, we cited the Kalima case, is you can't get money damages or some kind of claim here based upon a statute in this case. And so the life insurance statute only says that there is a cap and we will fund the cap. It doesn't say you have to go buy a plan. It just says fund this cap. That's their misreading of the statute as to what a cap is and what the funding is. It is in the discretion. Again, I cite Chevron deference. It is within the discretion of the EUTF to decide how much life insurance. The life insurance issue has always been different for retirees and actives. The actives have always had, when you're young, you get more life insurance. When you're old and you're past 65, your need for life insurance drops dramatically.
Actually, your need increases because you have less time left.
Yes, but the amounts of money that you need generally, because you don't have to provide for a family and children and education, things like that.
And life insurance is a benefit. It doesn't necessarily benefit the retiree. It benefits their beneficiaries.
Yes.
I mean, that's the whole point of it.
I totally agree with you, Judge Cahill. So I think, let me just see in my notes here.
Well, while you're thinking of something else to address, I have a question again on the attorney's fees. I mean, your position in the briefs, I know you're saying you're going to rest on your briefs, but your briefs are asking for $13 million on behalf of the state under 607-14. I think the plaintiffs also asked for attorney's fees under 607-14, so it seems like it applies, 607-14 being a sunset type of case. The challenge, of course, is the chilling effect on class actions and whether class actions should be somehow treated differently, right? I mean, they point to Kawashima, and what's your response to that?
And I understand that, but, their choice, the plaintiff's choice, was to bring a contract action. And 607-14 has always been there for contract actions. And if you can bring a tort claim there's no attorney's fees generally. If you decide you want to go for the contract action, then you've got to take the medicine, the good with the bad. And our view is that the plaintiffs in this case deliberately chose a contract action, and they need to be held accountable for that.
So who's supposed to take the medicine? Meaning the named plaintiffs, everybody in the class?
It could be either.
Well, what do you recommend and why? You're trying to inform us about what we should do.
So I think that the named plaintiffs would have to accept the responsibility for that because they chose to be the named plaintiffs. They chose to represent the class. And so it would be fair to impose that upon them.
So then chilling effect be damned. Because that's
Excuse
going
me?
to have chilling effect be damned. Because that's going to have a massive chilling effect on a very small group of people.
I understand the potential of the chilling effect, but you know that comes with the bringing of any contract action generally. While I recognize that they are citing a prior Supreme Court order that was not, I don't believe it was published, but exists. The other cases we cited on this have indicated that the chilling effect is a factor, but not a dispositive factor in other states that have considered this issue of attorney's fees. So,
But the difference is, though, is that if this were, I agree with you. If it's a contract action, you are the plaintiff and you don't prevail, you know what your contract damages are. Okay? Got to prove them with reasonable certainty, except in certain instances. But in a class case, you know what your, as the named plaintiff's, damages are, but you don't know what all the other people are. You have to rely upon someone else, namely the attorney, to tell you, well, this is what it is. There's a distinction between the named plaintiff we agree with, or maybe, but you don't know what everybody else is.
and I understand that, but part of that is a calculus that the plaintiff's attorneys make as well when they decide to bring the claim.
Thank you, Mr. Lee.
Thank you very much.
Let me take these issues in reverse order. The issue of whether a class representative is liable for fees based on the whole case or just their own stake has already been decided by this court. In a case involving the state, it was briefed, it was argued, they lost. They come before this court hoping to reopen it, but never citing their loss. I mean, that's a shameful thing, but the reality is the issue should be closed. They've given no good reason to reconsider that. With respect to class notice, my recollection is that it was given in the course of monthly documents that the state sends out to all retirees at some point, and I can't tell you exactly when, but I could provide that information. There was notice.
From the state.
From the state, yeah. With respect to whether this was a contractual case or just a tort case, the answer is in Article 16, Section 2. It said the protection of accrued benefits is a contractual right. And that's why we get to the assumption statute. And that's why if you look at the entirety of this case, when we stopped them in their tracks after 15 years of making adverse changes, and they stopped increasing copays, they stopped increasing out-of-pocket expenses. And the world didn't stop, by the way. They just stopped. We were the prevailing party. With respect to fiduciary duties, you're right. We did say that Justice Rechtenwald and the other trustees were guilty of breaching their fiduciary duties because beginning at the birth of the EUTF, they started in exactly the wrong direction. They said, we can reduce benefits. There is no constitutional protection. It took 15 years to get them back on track. As a fiduciary, your first duty is to do things right. And when you realize you've done exactly the wrong thing for 15 years, you think you might go back and say, gosh, what did I do wrong? Who did I hurt? But they didn't. They never did. And the problem is that when you have health insurance, you can reduce the benefit either by increasing the amount of costs that the insured must pay or reducing the scope of the coverage, right, by taking away. They didn't take things away. We acknowledge that. But what they did was they increased the piece of the pie that the insureds, the retirees had to carry on their own back, got bigger and bigger just because of the transition to the EUTF. And it wasn't a matter of simply making inflationary changes, and it wasn't a matter of copays always increasing. That's false. They didn't always increase. It was a matter of jumping up the copays by 60% or 70%. It was a matter of adding thousands of dollars per family on the maximum out-of-pocket expenses. And so that it went from X to 3X as a result of reducing coverage. How do you reduce the value of health coverage? You make the insured pay more. We all know the difference between good coverage and bad coverage is the insured pays more. And that's what happened here.
Under Dannenberg, though, I mean, there's a clear recognition that the legislature, the state can change. It's not a set required group of benefits, right?
Absolutely right.
There's a recognition that they can change it because out of necessity. I mean, part of the reason for going to the EUTF was survival of the coverages, apparently, is what their argument is.
Well,
right?
that was the argument.
Right.
That was the argument. I mean, in
Right.
fact, let me talk about that because Judge Crabtree mentioned the state fisc. But if you look at the record, you will find that there are two things that bear directly on that point, disprove the state's concerns there. There is an exhibit, plaintiff's 360, P360, that reflect the fact that year after year after year, the EUTF and the counties told the state auditors that losing this case would have no material impact on the finances of the state. So the idea that somehow they had to do this because they had to save the state is simply a lie. They were telling the auditors no material impact. The second thing that bears on this is the caps. In 87A33, the legislature put monthly caps on the payments. Those caps have always been higher than the amount actually spent. So the legislature has been on top of this, saying this is how much we can afford to pay. The EUTF has been spending less. To suggest that they had to make changes to save the state when the legislature said, by the way, here's more, is just, demonstrates the absurdity of the position. With respect to continuity, Judge Cahill, in phase one of the case, we addressed this issue. There were documents where people were told there would be continuity. It wasn't simply something that somebody made up. They were told there was continuity. With respect to comparability and relatedness, those are two very different things. Related means if I'm going to take away drug coverage or make you pay more for your drug coverage, I have to give you better drug coverage. And comparability means it has to be the same value. The Alaska cases teach this. And Mr. Louis would have you believe that you should simply confine yourself to exactly what Dannenberg says. I would suggest that Dannenberg teaches a broader message, and that is you look to the Alaska cases because the Alaska Supreme Court, for whatever reason, has received and heard and decided issues about this issue, about this this constitutional protection many times. Of course, they've refined the analysis. Of course, they've made it stronger, clearer, and given more guidance. That's why I think you ought to look to the Alaska cases, not because this court's inferior to that court, but because this court has already accepted the wisdom that they've offered. And what they teach is clear and consistent. You has to be both related and accompanying and of equal value. So Mr. Louis argues that cost sharing is a small part of the pie. The fact is, from the standpoint of the retirees, cost sharing is where the game is. What's the burden on their backs when they retire? And when the state increases that cost sharing burden, in some cases by hundreds, some cases by even thousands of dollars for a family, that's a problem. and it needs to be addressed. Mr. Louis says there's a lot of things we didn't show, and he objects to Mr. Brandon's analysis, which shows that the percentage of the pie put on retirees' backs grew. What he offered instead through his experts was something called the PMPM, the per member per month expense. That's just another word for actuarial equivalence or spending the same dollars that this court rejected in Dannenberg. This court said you don't look to how much the state was spending, you look to the value of the benefits to the retirees. And when the retirees, if everything had remained the same, the retirees would have paid a whole lot less than they did. And Mr. Brandon's report shows that tens and tens of millions of dollars were dumped onto the backs of retirees because the state was trying to save money on the false belief that it had absolute right to do that, as long as what it gave was a reasonable program. I appreciate your time, and if I have nothing further unless you have questions. Judge Ashford.
Thank you, Mr. Olson. I want to return to attorney's fees briefly.
Yes.
And I'm going to give two qualifying statements before I ask you the question. Number one, this is intended to be an information-seeking question and not combative or argumentative.
Yes,
Secondly, at the very end of your initial statements, you brought up attorney's fees, and you said something to the effect that, of course, the plaintiffs prevailed because of changed policies over the years. You got out one sentence on that, maybe two, then you were done. Mr. Louis alluded to it. I would like you to explain to me what those changed policies were that you referred to that show that your plaintiffs are the prevailing parties.
Thank you, Your Honor. Yes, in exhibits plaintiffs 388 and plaintiffs 207, there is a reflection that there is evidence that the EUTF stopped imposing higher copays, deductibles, and coinsurance requirements on the retirees because of this case. In the first, it says we're not going to impose diminishments until this case is settled. So what we did was we were able to stop them from continuing to increase the amount.
Okay, and a follow-up. If I wanted to figure out in my mind who the prevailing party is in this lawsuit, is there anything else you point to in terms of a victory and accomplishment, something you plaintiffs prevailed on?
I would point to Everson, I'd point to Dannenberg, and the fact that when this case started, if you look at their documents, they said, we owe no responsibility to the retirees other than to give them what might be in some circles considered a reasonable policy, as opposed to what they recognized was among the best policies anywhere in the country. And we stopped them from that, from further reducing based on their belief that they could. We turned them around completely on that issue.
All right, I want to thank both counsel for your argument today.
Thank you.
And the court will take the matter under advisement.
Thank
Thank
you.
you very much.